And now we're going to discuss the legalities of reporting. And our speakers for this session are Meg Savage and Sarah Clark Davis. Meg Savage graduated from the University of Kentucky College of Law in 1988 and served on active duty with the U.S. Navy Judge Advocate General Corps in San Diego and Key West. Upon returning to Kentucky, she worked as an assistant Commonwealth attorney in Russell, Wayne, and Clinton counties, and then worked for the Appalachian Research and Defense Fund of Kentucky in Somerset. She moved to Anchorage and worked for Alaska Legal Services as their family violence project attorney. Returning to Kentucky in 2006, Ms. Savage began working as legal counsel for the Kentucky Coalition Against Domestic Violence, which was mentioned earlier in our presentation. This coalition oversees and supports 15 state and federally funded domestic violence shelters across our state. Currently, Chief Legal Officer, Ms. Savage provides technical assistance and training statewide on issues touching upon domestic violence and the court systems. She also lobbies at the state and national level for passage of laws, which will increase the safety and well-being of domestic violence survivors and their children. And now, Sarah Clark Davis, who is the Associate General Counsel for Norton Healthcare. We're so happy to have you with us today, Sarah. In her role, she is responsible for managing professional and general liability claims and litigation against the organization, as well as advising the organization on medical issues and risk mitigation. Prior to joining us here at Norton, Sarah was a partner with the law firm of McMaster's Keith Butler, where she focused her litigation practice on representing hospitals, physicians, long-term care facilities, and other healthcare providers in medical negligence and wrongful death claims. She's a member of the Kentucky and Louisville Bar Association, the Kentucky Defense Council, the Kentucky Academy of Hospital Attorneys, the Kentucky Society for Healthcare Risk Management, and is a barrister with the Louisville D. Brandeis Inn of Court in Louisville. Welcome to both of you.
Thank you. Well, I think I'm first up, so I'll go ahead and get started, and I'll go ahead and share my screen so I can throw my PowerPoint up there for everyone to see. All right, well, good morning. I'm sure that you've already had a very interesting morning learning all about domestic violence, something that we often also call intimate partner violence, which is a little bit more inclusive, at least under Kentucky law definitions, because it covers more relationships. So today I'm going to be talking about what healthcare providers need to know about any of the Kentucky legal requirements for when you are dealing with a patient who has made a disclosure of abuse or you have reason to believe is experiencing domestic or dating violence and abuse. So first, I was asked just to talk a little bit about the prevalence of intimate partner violence in Kentucky. And unfortunately, as with many statistics or data points, Kentucky has the highest reported rate of intimate partner violence in the nation, and this is according to the CDC. So almost 40% of Kentucky women and a little over 30% of Kentucky men have experienced rape, physical violence, or stalking from an intimate partner over the course of their lifetime. So that's a sad statistic, one which my organization continues to try to bring those numbers down. But as I'm sure you probably heard this morning, it really takes a concerted community effort on a lot of different fronts to address intimate partner violence in our society and in our state. Again, according to the CDC, almost 23% of Kentucky women reported having an injury or need for medical care due to intimate partner violence. And in the report that the CDC puts out every so often, they did not give that same data point for Kentucky men. So I don't have that for you. And this is the National Intimate Partner and Sexual Violence Survey that's conducted. It's been going on since 2010. And as I said, they do it every couple of years, and they do interviews with thousands and thousands of people across the country. So that's where this information is coming from. And you may have heard some of these statistics this morning on a national basis. 1 in 4 women and 1 in 7 men experience severe physical violence from an intimate partner. 1 in 3 women and 1 in 4 men have experienced some form of physical violence by an intimate partner. Again, these are coming from that CDC study. 1 in 7 women and 1 in 25 men have been injured by an intimate partner. 1 in 10 women have been raped by an intimate partner. And even though the percentage of men who are reporting that they have experienced rape is much, much lower than it is for women, it is of note that approximately almost a third of male rape victims report that they were raped by an intimate partner. And of those intimate partners, predominantly those were male partners. And then also stalking, again, Kentucky. This is not a Kentucky statistic, but Kentucky has one of the highest rates of stalking in the country. 1 in 7 women and 1 in 18 men have been stalked to the point where they felt very fearful of harm. So we have a lot of work to do. And I hope that this morning's information put in the hands of everybody who's participating in this webinar, more knowledge to be a part of the solution when it comes to how do we help people who are experiencing this type of violence get out of these relationships. Even though there is a lot of data about men and people who identify as male experiencing violence at the hands of a partner, it still actually is a very gendered form of violence. And I think that nothing shows this more clearly than when we look at intimate partner homicides. So nationally, 1 in 13 male murder victims are killed by intimate partners. However, 1 in 2 female murder victims are killed by an intimate partner. So you can see the great disparity there. Women are, and people who identify as female are at much higher risk during the course of their lifetime of ultimately being murdered by an intimate partner or an ex-intimate partner. And 65% of all murder-suicides involve an intimate partner. And of that number, 96% of those murdered are female. So when we talk about intimate partner violence at KCADV, we may kind of switch back and forth between gender neutral pronouns and sometimes say she and sometimes say he. But I think as a society, we should recognize that because it's a form of violence that's based in power and often in privilege, that it is tends to have a much more disparate impact on both women and individuals who have identities of any of our marginalized communities, such as people of color, people who identify as LGBTQ, people who have disabilities, etc. So I thought I'd take a quick snapshot of intimate partner homicides in Kentucky during this year. Anybody who looks at news reports has probably seen a lot of coverage of the high rate of intimate partner homicides that we're experiencing this year. So this is data that KCADV has collected in a very informal way. We had a bill that passed just this past session that's going to create a very robust domestic and dating violence data collection report for Kentucky for the first time. We've never had anything like that. So we're excited about that. So the way we collect this information is very informal, just through, seeing things in the news, hearing things through our programs, et cetera. So we've identified what we believe are 35 victims of intimate partner homicide, starting with January 1st, and the last incident was December 10th. And of those, 33 were female victims with a male perpetrator, 2 were male victims with a male perpetrator, and 1 was a male victim with a female perpetrator. 30 of these homicides were committed with a firearm, 1 through blunt force trauma, 2 through stabbing, and 2 through strangulation. Of note, as is always the case when we look at this type of data, there were 9 co-occurring suicides. That's a very common pattern with intimate partner homicides. And this year so far, there have been 12 additional collateral victims, involved in that immediate incident where a survivor of abuse was killed. And those victims include children, relatives, neighbor, and police. Probably many of you heard about the incident out in Eastern Kentucky earlier in the year where law enforcement was attempting to serve an emergency protective order on an individual who barricaded himself in his home and opened fire, and 3 police officers were killed in that incident. Unfortunately, I know that this year there's been multiple children that have been killed. And most recently, this most recent homicide that occurred on December 10th in Louisville or Jefferson County involved a man shooting his wife and his 2 daughters who were aged 12 and 17, I believe. So again, it's something that as practitioners, you will see survivors of intimate partner violence, whether they're disclosing that fact to you or not, you will see them. And your response to them may be really super important because it takes a lot of trust for someone to disclose that they're being abused and they don't know, what the reaction of that individual is going to be. So I hope that what you learned this morning and what we talk about now will encourage you not to shy away from this as something that's just too overwhelming. And as a physician or any of the other participants in this webinar, that you're too busy, you don't know how to respond. Hopefully that the information you receive today will help you along that path. So I do want to talk about the legal requirements for healthcare professionals. And I do want to emphasize that there's no mandatory reporting of intimate partner violence under Kentucky law. So some people have that sense that if there is intimate partner violence, they become aware of it, that they have a duty to report that to somebody. And that is not correct. It used to be correct. We used to have the mandatory reporting of spouse abuse under Kentucky law, and it only pertained to spouses, not to unmarried partners. And those reports went to Adult Protective Services at DCBS, who would then do an investigation. That law was old. It was about 40 years old. And over the course of those decades, the way domestic violence was being addressed in Kentucky shifted in a big way. And so the law sort of was not working in any way, shape, or form as it was intended. So we did switch in 2018 to a new setup such that certain professionals that are listed in the statute do have a duty to provide educational material and information about domestic and dating violence, information about local victim services resources, and how to obtain a protective order. And this is going to victims of domestic and dating violence and abuse that you may be working with. So talking about this statute, I thought it would be helpful to look at some of our legal definitions that we have under Kentucky law. Now, this morning, you talked about domestic violence and probably heard about the power and control wheel and coercive control. There are many different weapons that an abuser can use against their partner in order to keep them under their control, which is their intention. But our legal definition is a little bit more narrow. So it's found in this statute, KRS 403.720, and there's a definition of domestic violence and abuse. So it's physical injury, serious physical injury, stalking, sexual abuse, strangulation, or assault, or the infliction of fear of imminent physical injury, serious physical injury, sexual abuse, strangulation, or assault. And that's occurring between family members or members of an unmarried couple. Now, I'd like to point out a couple of things here that this infliction of fear factor was deliberately put into the law because this series of statutes outlines how one goes about getting a protective order in Kentucky. And so the idea being that it would be nice for somebody to be able to get that protection in place before they're actually harmed. So that's where that point comes in. And then family members or members of an unmarried couple. So when our protective order statutes were first put in place, I believe, if I'm not mistaken, it was only between spouses, and then they expanded it to people who are in a relationship that's like a marriage, even if they haven't been married. And then we've expanded it in steps and increments over the years. So right now, under this one set of statutes, there has to be this relationship between the individuals such that they're family members or members of an unmarried couple. And then in a moment, we're going to talk about a newer set of statutes that expanded these protections to people who are in a dating relationship, people who've been sexually assaulted, and people who've been stalked. So what do we mean when we say a family member? So under Kentucky law, this is defined as a spouse, a former spouse, a grandparent, a grandchild, a parent or child, a stepchild, or any child where the child is being abused by someone living in the same household. So those all qualify as family members. And why is that important? Well, it is important when it comes to who can get this type of protective order under Kentucky law. It also comes into play in a smaller aspect when we talk about our criminal code. So assault fourth between family members, that allows police officers to make an immediate arrest without a warrant, without having seen the assault occur in their presence. And so that's those are kind of why we needed to define these terms. And then the other prong of this particular type of protective order is members of an unmarried couple, and that's having a child in common, or they live together as intimate partners, or have lived together as intimate partners in the past. So obviously, you know, the advocate's definition of domestic violence and abuse goes, you know, far beyond this narrow construct. Why is it important for you, the people who are participating in this webinar? Because we are going to talk about your obligations to give informational and educational material to your patients when there is a disclosure. And so it's a disclosure of domestic violence and abuse or dating violence and abuse. And in order to understand what domestic violence and abuse is for that purpose, we're going back to this statute. So we're talking about family members or members of an unmarried couple. Now, in a moment, I'll tell you that it's even more restricted, because when we are talking about your obligations under this statute, which is found in KRS 209A, we are really just talking about intimate partners. So you can see here that, you know, the grandparent-grandchild relationship is included, and the parent-child relationship is included in these definitions. But your obligation under what I'm talking about today doesn't pertain to those relationships. So they're in there because we understand that a grandparent might be abusing a grandchild might be abusing, you know, an elderly grandparent, same with parents and children. But for today's purposes, we're really focusing in on intimate partner violence. So those are the definitions of family member and member of an unmarried couple. And then when we go over to this newer set of statutes, which came online in 2016, 2017, this is when we opened up that umbrella to also provide these same protections, our protective order statutes, to people who are experiencing dating violence and abuse, sexual assault, and stalking. So we're not going to talk about sexual assault or stalking today in terms of those things happening between people who don't necessarily have this, you know, intimate partner relationship. So certainly you could be sexually assaulted or stalked by a coworker, a neighbor, someone you live in the dorms with, a friend, or someone that you don't even know. But we're not really talking about that today. Just FYI, when someone does experience something like that, then they are entitled to go and seek a protective order as well under Kentucky law. But today we're just talking about domestic and dating violence and abuse. So the definition of dating violence and abuse is very similar, almost identical to domestic violence and abuse. So again, physical injury, serious physical injury, stalking, sexual assault, strangulation, or again, that infliction of fear that something like that is imminently going to happen, because we want to allow people to apply for protection before they actually get hurt. Now, for dating violence and abuse, this is occurring not between family members and members of an unmarried couple, but between people who are in or have been in a dating relationship. And I know nowadays in the year 2022, if you ask different people of different ages, what does dating mean to you? You're going to get a wide variety of answers. But for our purposes under Kentucky law, we have a very wobbly, wiggly definition of a dating relationship. It's a relationship of a romantic or intimate nature. So for your purposes, as people who, might need to do something because you're working with a patient who's disclosing some form of abuse, I would certainly err on the side of, making it as broad a definition in your head as possible. And especially if the person is reporting that my boyfriend, my girlfriend, et cetera, has been abusing me, take that as a given. That's a dating relationship. You're not a judge. You don't have to make the final call in a protective order hearing whether these two people are actually dating or not. All right. So those are the relationships that you would be on the lookout for: family members, members of an unmarried couple, or people who are in a dating relationship. And so what are we talking about when we talk about the actual abuse that's occurring? And again, this morning you probably heard about the power and control wheel, and there's financial abuse, and there's emotional abuse, there's isolation. There's a lot of components to intimate partner violence. But for purposes of Kentucky law, we're talking about physical injury. That's a very low standard. Anything that causes substantial physical pain or any impairment of physical condition. So it could basically be, you slap somebody and you leave a mark on their cheek, you punch someone, you kick them, you shove them and hurt them. Just about anything is going to qualify as a physical injury. Serious physical injury, we make a major leap there. So this is a physical injury which creates a substantial risk of death or causes serious or prolonged impairment of health, disfigurement, loss of function of a bodily organ. So, that may be present. You may be dealing with someone who has experienced that, but just keep in mind that in order for the law that we're talking about today to be triggered, it only has to be a physical injury. Sexual abuse, that's subjecting another to sexual contact without consent, and then sexual assault. Those are usually considered as rape, sodomy, or the various levels of sexual abuse. Stalking, we think of stalking maybe as somebody following someone around in public, but under Kentucky law, it's defined as a course of conduct. So there has to be at least 2 incidents aimed at a specific person that serves no legitimate purpose and that would cause a reasonable person to suffer substantial mental distress. And it includes an implicit or explicit threat of sexual contact, physical injury, or death. Phew, that's a long definition. So again, for your purposes, if someone says, well, my ex-partner is stalking me, I don't think you need to go through this, legal analysis of, oh, wow, does that really meet the definitions of stalking? I think you can just take it at its face value. What you're going to do when this information is given to you is simply to provide that information with that person with information. So there's no reporting going on. We don't have to worry about HIPAA or anything like that. So that's our legal definition of stalking, though. And strangulation is a crime in Kentucky. It came on the books few years back as a specific crime. And it's defined as impeding the normal breathing or circulation of blood of another without consent by applying pressure on the throat or neck or blocking the nose or mouth. It's a very common form of intimate partner violence when there's a lot of physical violence going on in the relationship. An assault is a generic term, but causing physical injury to another. And then again, or the infliction of fear that any of these crimes is imminently about to happen. So even though this is found in our protective order statutes, and a protective order is a civil case, it's person A versus person B. The Commonwealth of Kentucky is not involved in this case. Everything that I've talked about is actually still a crime. Even the infliction of fear that you are imminently going to injure someone is the crime of menacing. It's a Class B misdemeanor. So when people say, oh, protective orders, you could do anything, you could look at somebody funny, you could insult somebody, or there, you could just be mad at someone and go get a protective order in Kentucky. That's not true at all. What the party asking for the protective order has to show is that one of these things has happened, and that is actually criminal behavior. All right. And so those same definitions for assault, physical injury, strangulation, stalking, etc., those are the same for dating violence and abuse as well as domestic violence and abuse, because they all are pulled out of our criminal code. Now, what's new in 2022 is domestic and dating violence also includes animal abuse. So again, just something for you as a healthcare practitioner to be listening for, to pay attention to if you were to hear it. And, who knows whether somebody would even think to disclose this. But there is a definite connection between, sort of malicious abuse of animals, especially for the purpose of controlling your partner or other family members, and then other forms of human abuse, whether that's intimate partner violence, child abuse, elder abuse. And so that's something that we need, to be paying attention to if it comes to our ears. And so now our protective order statutes also include animal abuse as a form of domestic or dating violence. So any conduct prohibited by these criminal statutes, which are abuse or torture of an animal, or the infliction of fear of such imminent conduct taken against a domestic animal when used as a method of coercion, control, punishment, intimidation, or revenge, directed against a family member or member of an unmarried couple, or people in a dating relationship who has a close bond of affection to the domestic animal. And domestic animal means a dog, a cat, or other animal that is domesticated and kept as a household pet. And so this is something that some people, I think there was an organization in Louisville in particular that really wanted, to get this into our protective order statutes. And so that just happened this year, earlier in 2022. So this is now the law as well. Okay, so we've talked about these definitions of domestic violence and abuse, dating violence and abuse, family members, members of an unmarried couple, people in a dating relationship, what types of abuse are we talking about? So those are the things you should be listening for. And then, if there's a disclosure, or even if there's not a discrete disclosure, I am being abused by my partner, but if there are other indicators that give you a reasonable cause to believe, and so it's sort of like the child abuse reporting statute, then that triggers the legal mandate for professionals. So, and professionals has a specific definition, and I'll talk about that in a second. So if a professional has reasonable cause to believe that a victim with whom he or she has had a professional interaction has experienced domestic violence and abuse or dating violence and abuse, then here's what you need to do. The professional shall provide the victim with educational materials related to domestic violence and abuse or dating violence and abuse, and including information about he or she may access regional domestic violence programs or rape crisis centers and information about how to access protective orders. So that's your obligation. And, you know, in my mind, I'm not a healthcare professional, but in my mind, it's relatively minimal. You know, somebody needs to be giving that individual written information that they then can take, read, digest, and use at a time when it's safe and appropriate for them to use it. If they don't want it, they don't have to take it, but at least you've done your obligation of offering it to them. And I'll tell you later on in this presentation that we do have a brochure that KCADV put together, and that's available to be downloaded online if that's what you want to use. Or your organization, you know, can create its own materials. So the idea is that, you know, long ago, or not too long ago, when we had our spouse abuse reporting law, and it was mostly coming from law enforcement and healthcare professionals, especially mental health care professionals, where they were reporting, you know, hey, you know, there's been this incident of spouse abuse, or hey, I'm working with a patient who's disclosed spouse abuse. Then it was up to APS to try to track that person down. And then if they could track them down and contact them and offer them services, basically all they were doing was referring them back to our domestic violence program. So as was said at the very beginning, KCADV has 15 member program domestic violence shelters across the state. There's one in each area development district. And those shelters are funded through state and federal funds. And they serve all 120 counties in Kentucky. And then similarly, we have the Kentucky Association of Sexual Assault Programs, and they are over the rape crisis centers. So there's a rape crisis center in each ad, and they serve all 120 counties as well. And so, you know, it just makes a lot more sense, and we have changed the law to reflect that, you know, if somebody is having an interaction with somebody where either they're disclosing abuse or there are signs that lead you to believe that this person is experiencing abuse, it's just so much more efficient to give them that information right off the bat while they're in your office. Nobody has to track them down later. And then it's up to them to decide whether they want to use that information. If it's helpful to them, they may save it. Maybe they'll use it next month. Maybe they'll use it a year from now. Maybe it's not safe at all for them to have that on their person, you know, in their belongings, you know, and they don't want to take it with them. Maybe they're not ready to take that step to leave that abuser. But you will have done your duty by giving them that information. So again, I want to talk a little bit about some more definitions that are under this statute. What do we mean when we talk about a professional? So many of you who are on this webinar will probably fall under this definition. So it's pretty broad, but it's not universal. It's not like our child reporting law, which is everybody in the state of Kentucky. It doesn't matter who you are. Okay, so we're talking about physicians, osteopaths, coroners, medical examiners, a medical resident, a medical intern, chiropractor, nurses, dentists, optometrists, emergency medical technicians, paramedics, licensed mental health professionals, therapists, anybody who works for the Cabinet for Health and Family Services. And then we're going further, you know, away from those healthcare professions to childcare personnel, teachers, school personnel, anyone who's an ordained minister or denominational equivalent. So that means, you know, of any faith, a victim's advocate, or any organization or agency employing any such professional. So if you work for the hospital, then the hospital also has that obligation to make sure that that individual is getting that information. And so if you're not on this list, then I would say, well, you don't have the legal obligation to provide this information. But I would still encourage you in your professional dealings with your patients to consider whether or not it's appropriate to share the information that we're talking about, even if you don't have the obligation to do that. you may be helping somebody to make that decision and be able to get away from that abuser. Oops. All right, so if we go back to this obligation, when I have reason to believe that a victim, okay, so we do have definitions for victim under this statute, any individual who is or has been abused by a spouse, former spouse, or intimate partner with whom they live or have a child in common, or an individual who is or has been abused by a dating partner. Okay, so we're going back to those definitions we talked about earlier, where we're talking about family members, so that's a spouse or a former spouse. We're talking about members of an unmarried couple, someone who they live with or have lived with, or they have a child in common with, or we're talking about people who are or have been in a dating relationship. So that's how those definitions come back into play. And again, as I said earlier, this statute in the chapter 209A that triggers this obligation on your part only covers intimate partners, past or present. It doesn't cover child abuse victims or abuse of people who have a disability. Those types of abuse are covered under other laws, and we'll talk about those really briefly in a minute. And so, again, this obligation to provide this material only applies to, as you can see, spouse, former spouse, intimate partner that they live with or have lived with, or a child in common, or dating partners. Okay, and again, what kinds of abuse are we talking about? You're listening to this person and they're telling you about financial abuse. They're telling you about psychological or emotional abuse. Those don't really fall under this definition. They don't trigger this obligation. But again, I would say if someone's experiencing that, why not share this information with them? They don't have to take it with them. It may be helpful to them. You may be helping them out. And what they're experiencing may be leading up to something more serious. So again, these same things that we already talked about, physical injury, serious physical injury, stalking, sexual abuse, strangulation, or assault, or the infliction of fear of imminent physical injury. I'll just give you a quick example of this because, you may be saying to yourself, well, what does that really mean, this infliction of fear? So I had a client long ago who had been married for about 10 years. And early on in her marriage, her husband hit her in the face with his fist. And he was wearing a class ring that he always wore, and he cut her face. And so she did call the police, and he was arrested and charged with assault. But they reunited, and then over the course of this abusive relationship, he had learned that he should take his ring off when he was going to hit her, which he continued to do for a while, for the first couple of years of their marriage. And so he was in the habit of taking his ring off, right? And then that was like, yeah, I'm going to take my ring off and then I'm going to hit you in the face. And so ultimately, he didn't have to hit her anymore. All he had to do was take his ring off. And she knew what was coming. She knew that if she didn't stop, or, whatever it was making him angry, that, she needed to back off or whatever, or he was going to hit her. And so when she finally got to the point where she was ready to leave this relationship, her statement, I think, on her protective order petition was, well, we were in an argument and he took his ring off and I ran out the door. So contextually, that doesn't mean a whole lot. And you have to, have that context to know that by taking his ring off, he was placing her in fear that she was imminently going to be injured. So that's just one example of, how that may come about. So where can you find the information that you're supposed to give to your patient? So as I said earlier, we do have a Help Us Here brochure, and you can find that on our website right there, kcad.org. dv.org. If you look over to the left on the homepage, you're going to see KRS 209A referral information. So that's the series of statutes that we've been talking about. And there's the direct link to a page that has a lot of resources on it. And you'll find that the first several of them are various formats for the Help is Here brochure. It's in English and Spanish. You can print it out as a nice shiny brochure with graphics, or you can just print it out as text. And so you have some different options there. And medical practices and agencies are free to develop their own material if they like. It has to cover some educational material about domestic and dating violence. It has to cover where to find your local domestic violence program or rape crisis center, and it has to cover some information about how to get a protective order. Is there anything else that you're obligated to do? Professionals shall report domestic and dating violence and abuse to law enforcement if and only if, and that's hugely important, if and only if the victim requests it and after discussing the reporting with the victim. So if you're dealing with someone who says, yes, I want to report this to the police, can you help me do that? Then you are obligated to make that report, help them make that report. Also, professionals shall report to law enforcement their belief that the death of a victim with whom they had a professional interaction is related to domestic and dating violence. So this was sort of put in the statute to sort of circumnavigate some of the privacy and confidentiality requirements that many professionals have, even after the death of a patient or a client, someone they've been working with. And you have information and you want to share it with law enforcement, but those confidentiality requirements may still apply. And so this lets you share that information with law enforcement without having to worry about that. And then there is an immunity portion to this statute. Anyone acting upon reasonable cause in compliance with this chapter shall have immunity from civil or criminal liability. However, knowingly or wantonly violating the statute is a Class B misdemeanor. So that's a little bit of teeth put in there. There's other pieces to the statute that don't necessarily apply to like healthcare professionals. But, you know, it's a fairly simple thing to do, fairly innocuous. You're not reporting anybody, going to get them in trouble or cause havoc in their lives. So I really hope that you will do it when you feel like you need to. Just very quickly, I think I have 6 minutes left. So I don't know how much more of this I'm going to get through, but of course we do still have mandatory reporting of child abuse, neglect and dependency. That did not change when we changed the law that got rid of spouse abuse reporting. Also, the abuse, neglect, or exploitation of a vulnerable adult. We still have that obligation. Those are universal mandatory reporting laws. Again, no statutorily mandated reporting of domestic or dating violence and abuse. So very quickly, child dependency, abuse, and neglect. Any person having reasonable cause to believe a child is dependent, neglected, or abused has to report that to the KSP or the Cabinet for Health and Family Services or local law enforcement or a local prosecutor. Most professionals report to CHFS using the hotline phone number or the online portal. And physicians specifically may be required to submit an additional written report within 48 hours of any additional information that they may know if that's requested by CHFS. A dependent child is just simply one who, through no fault of their own, the parent cannot see to the needs of the child. An abused or neglected child, on the other hand, there's a long list of the way a child can be abused or neglected. But what's really important here is that there's this relationship between the child and the adult. So the adult is a parent, a guardian, a person in position of authority or special trust, or other person exercising custodial control or supervision of the child. And that's important when we talk in a minute here about what happens if the patient I'm dealing with is a minor and they're experiencing domestic violence and abuse or dating violence and abuse at the hands of a partner. How do I report that? Should I report that? So this is just a list of the various statutory ways that a child could be abused or neglected. Hopefully you all are very familiar with this. And I think I often say that, well, you know, in your head, if you're thinking, is that abuse or neglect? It probably is, because it's a very comprehensive statute. So I'm not going to go over this in depth, but keep that in mind. Obviously, we also have reporting requirements for what I call vulnerable adults. So this is someone with a physical or mental disability that's unable to manage their own resources, carry out the activities of daily life, or protect themselves from neglect, exploitation, or a hazardous or abusive situation. So that's two-pronged. It's not just anytime somebody with a disability is being abused, but there also has to be that other component that they really lack the ability to protect themselves from that abusive situation. And those reports go to CHFS, and you can use the same hotline number as for child abuse reporting. Abuse and neglect are pretty self-explanatory under this statute. Exploitation means financial exploitation. So that's also supposed to be reported. And so domestic or dating violence and vulnerable adults. If the victim of domestic or dating violence and abuse is a person who has a disability and who cannot protect themselves from the abusive situation, then the duty that we talked about to provide educational material always applies, but the situation would also need to be reported to DCBS if this person is, in your opinion, a vulnerable adult. Oops, I think I skipped a slide. Yeah, domestic or dating violence and minors. Again, the duty to provide that educational material would still apply. If their abusive partner fits the definition of a person in position of authority or special trust, you could report it to DCBS as child abuse. But they typically will say it does not meet criteria for them to investigate. And I double checked on this recently with DCBS, and they said, go ahead and report it, and we'll figure it out. We'll figure out whether it needs to be investigated as child abuse or not, because DCBS doesn't investigate domestic or dating violence and abuse, but they obviously do investigate child abuse. Or if the parent of the minor is aware that the abuse is occurring and they're not being appropriately protective, then you could report that as, you know, child abuse or neglect on the part of the parent. So I think I am like running out of time here. So just very quickly, here's where you report child abuse and vulnerable adult abuse. Civil orders of protection. That's something that you should give your patients information about. Again, these are civil actions. It's somebody who wants protection from another individual. They may have an attorney, they may not. The other party may have an attorney, they may not. Under Kentucky law, we have domestic violence orders and interpersonal protective orders. Emergency protective orders are the first thing that you get if you're a family member or member of an unmarried couple. And then when you go to a hearing, that turns into a domestic violence order. Interpersonal protective orders are available for people who are experiencing dating violence or who were sexually assaulted or stalked by someone who they don't have any sort of intimate relationship with. You file usually at the circuit clerk's office during normal working hours. After hours, every county in Kentucky, it's a little bit different. You'd have to check with a police agency or the circuit clerk's office to find out where someone would file after hours. You're going to file in your county of usual residence or the county to which you have fled if you're escaping an abusive situation. It's all done on forms provided by the clerk's office or whoever you're going to, whether that's like a police agency or the sheriff's office. The petitioner fills that out. They're going to file that petition. It's going to be reviewed by a judge. And then the judge is going to make some decisions. And the judge is going to set the case for a hearing. If they feel that there's enough in the petition to show domestic violence and abuse or dating violence and abuse. And they may also issue that temporary order, an emergency protective order, or a temporary interpersonal protective order. The case is set for hearing. The respondent needs to be served. Anyone who's in Fayette County or the surrounding area knows that right before Thanksgiving, a woman went and applied for an emergency protective order, and the judge set the case for a hearing but didn't issue the EPO. The respondent, who's the other party, her estranged husband, he was served with the summons to appear in court, 10 days later or whatever. And he went and shot her and killed her. So typically you will see the emergency protective order also being issued, or the temporary order. The reason for that is to provide protection during that period when people are so vulnerable. The most dangerous time for a survivor is when they're trying to escape that relationship, when they're separating from that abuser. Most people file for a protective order in order to get that no contact portion. There's other things that a judge can order. If the two people share a residence, they can order the respondent to leave the residence, at least temporarily. A judge can address temporary emergency custody of children. And also they can address firearms. What happens at the hearings once the respondent is served? It's just like any other court hearing. The judge is going to make a determination. Has domestic violence and abuse or dating violence and abuse happened, and might it happen again? And so if the petitioner convinces the judge of that, then the judge will almost certainly enter that long-term order. In Kentucky, these long-term orders last up to 3 years. They can also be renewed. And then if the order is violated, the respondent could be charged with the crime, violation of a protective order, or they could be held in contempt of court, which also can carry potential jail time. It goes into a statewide law information network of Kentucky computer system. So it's available to all police officers all across the state 24/7, which should make it easier to enforce. And so that's very short shrift to our protective order process. Criminal domestic violence law in Kentucky, of course, something may happen. The police could be called. They may make an arrest on the spot. They may send a report to the county attorney's office. A warrant might get issued by a judge, or the individual who experienced the crime can go to the county attorney's office themselves and talk to the county attorney to see if the county attorney would file a criminal complaint. And then the prosecutor is in charge of that case, so the survivor has a little bit less control over that process. We don't have a specific crime in Kentucky, domestic violence and assault, but you usually see that charged as assault in the 4th degree. That's a misdemeanor. And then we do have felony assaults, but again, you have to practically kill someone in Kentucky in order to charge them with a felony assault. So we have a little bit of a problem with our law there. Other crimes you may see, criminal trespass or burglary, criminal damage of property, terroristic threatening, harassing communications, wanton endangerment, unlawful imprisonment, intimidating a witness, all the way up to homicide, as well as rape, sodomy, sexual abuse, stalking, and strangulation. So those are all criminal behaviors for which a survivor could seek protection from the criminal court system, either by going through the police or by going directly to the county attorney's office. All right, and so talking last about regional services. So again, at our website, you'll find more information about our 15 domestic violence programs, where each one of them is located, how they can be contacted. These are the services they provide: legal and court advocacy, case management, safety planning, support groups, counseling. Some have therapists, a lot of housing assistance, a lot. And of course, shelter for survivors and their dependents. We accept all gender identities and provide ADA and Fair Housing Act accommodations for people who have disabilities, including people who have service animals and emotional support animals. KSAP is over the regional rape crisis centers. There's their website. You can look for information about them on that site. 24-hour crisis lines, counseling and support for survivors, families, and friends. accompaniment and advocacy in hospitals. So when you see an advocate who's there in the emergency room while a safe exam is being performed, they're probably coming from their local rape crisis center. Court and law enforcement setting accompaniment, mental health and support services, referrals to community resources, and assistance with crime victims compensation fund claims. So how do you help an IPV survivor? Be supportive and don't be judgmental. That's like number one. Provide resources, give the survivor information in a safe way, which they can use when it's safe for them to do so, such as the Help Us Here brochure. Be ready to help if the survivor decides to leave, however you can in your professional capacity. Be prepared for it not to always work out the first or second time. It takes a lot of effort and strategizing to get out of these relationships. Keep documentation, which Sarah's going to talk about here in a moment. And, remember that the counterintuitive behaviors that you're seeing are probably the product of the abuse and trauma that the person has experienced. And that's me. And I'm going to stop sharing my screen. And thank you so much. I'm going to turn it over to Sarah.
Well, thank you so much, Meg. That was fantastic. And having not been part of the original half of this program, I understand, though, that you have been hearing about recognition of signs of potential abuse. Meg did a fantastic job sharing with you about reporting requirements. And so that is a fantastic segue into what I wish to speak with you all about, which is documentation and things that we can do proactively to assist patients or clients that are coming to you with complaints of potential interpersonal violence. So I am going to see if I can share my screen here. Just one moment. Just to give you a little background on me so you know the vantage point that I'm coming from with this, and I appreciate the very nice introduction Kim gave me earlier. I've been an attorney for approximately 20 years, and I joined Norton Healthcare. Thank you all. I joined Norton Healthcare right at the beginning of the pandemic in-house as associate counsel, but prior to that, I was in private practice defending medical malpractice claims. And as you can imagine, over the past 2 decades, I have spent the vast majority of my time reviewing documentation by providers. So it is a topic near and dear to my heart because I feel like documentation, especially in the world of electronic medical records that we are in, can be fairly burdensome at times, but I also feel that there are many ways that we can continue to improve upon our documentation. And if ever there was an instance where it was important, it would be in documenting interpersonal violence. So if you'll go to the next slide, please, and thank you for sharing that. Okay, so as we all know, there are a litany of reasons why it's important to have very thorough, detailed, well-documented records for our patients, but especially in the field of issues with interpersonal violence, because what we chart can play a very important role in the prevention, or at least in the mitigation of abuse. As Meg touched upon, your documentation may ultimately serve as legal evidence if your patient goes to the police or seeks legal assistance. In a legal proceeding, that medical record can be used by the patient to obtain protective relief, such as the protective order that Meg discussed. But it can also be used in less formal legal context to support a patient's assertions of abuse in seeking special status or exemptions, such as to obtain public housing, welfare, health and life insurance, victim compensation, and related matters. Your documentation should be clear, concise, and factual. And really what that does is that's going to help establish that the abuse has occurred by documenting the injuries. The medical record is often seen as one of the most important aspects of the patient's legal proceeding because it's going to constitute an unbiased, factual account recorded shortly after the abuse occurs, when recollection of the events is easiest for the patient. It also is going to help indicate when the violence was reported. It's very important for these matters for the patient to be able to build a timeline of the abuse events, both when the abuse occurred as well as when it was reported. And that also helps in timing of injuries. So ultimately, the way that we record this in the medical record is going to impact its admissibility in a court of law. And as you see there on the next slide, I did locate a study. It is a little bit old, from 2001, but this is from the National Institute of Justice by Isaac and Enos. I hope I'm pronouncing that last name correctly. And in this study, they reviewed 184 visits for medical care, where ultimately an injury or some notation of abuse was noted. And as you can see there were a number of shortcomings that were identified in the records. For instance, in the event, I believe there were 93 instances of an injury. There was only one photograph in those 93 instances documenting the injury. The body map that we sometimes see in records was only used in 3 of the 93 instances, although there were drawings made by the provider of the injuries in 8 of the 93 instances. And so what are some of the issues that we see with providers or concerns that providers have with regard to documentation? Obviously, we are concerned about the confidentiality of the records and the HIPAA rights of the patient, which is always one of our topmost concerns. We also see that providers have fear of liability in the manner in which they document the abuse in the medical record. One of the things we'll touch upon at the end of the presentation is there's always concern by the providers that recording information might inadvertently harm the victim. And we can talk about ways in which we can try to protect that from inadvertent disclosure. And as we see there, with this slide, there's always a little bit of hesitancy of the provider, confusion as to whether, how, and why to record information about interpersonal violence. We always tell folks in all settings, not just interpersonal violence complaints by a patient, that it's important to use your own judgment regarding what and how we document certain information in the patient's medical record, and being mindful of why we are documenting what we do document in the record that is pertinent to the encounter and the complaints that the patient makes. In some instances, we'll see that providers, in an effort to be neutral, they may use language to summarize the patient's complaints, which we'll talk a little bit about. And that doesn't always fully and objectively document the patient's injuries. So we want to be using the patient's words as much as possible. One of the things I wanted to note on before we get into additional important points about documentation is sometimes there's a concern by providers I hear of, I'm fearful of having to give testimony in a legal proceeding, which is an understandable complaint, right? No one likes to go to court, but also worrying about the admissibility of their records. And to put on my lawyer hat for just a moment, I won't bore you with all these rules, but as most folks are aware of, there are certain hearsay rules that prohibit out-of-court statements. However, there are exceptions that exist that permit testimony about diagnosis and treatment. There is also Kentucky Rule of Evidence 902, which allows certified medical records to be entered into evidence without the testimony of a healthcare provider to authenticate that the records are truthful and accurate. And one other thing that we're going to touch upon is excited utterances. There is a hearsay exception under Kentucky Rule of Evidence 803 that states that a patient's excited utterances in that patient encounter that you have with them is another exception to the prohibition on hearsay. These are statements made by the patient soon or during the event while they are in an agitated state of mind. These statements are felt to be a hearsay exception because they are felt to be credible, both because of their proximity and time to the event itself, and they are unlikely to be planned. So one of the things we will talk about when we talk about tips for documentation is it's important to, if possible, note the time that is passed between the event itself where the harm occurred and the time that the statements were made. And also describing the patient's demeanor when they are making these statements to you in the encounter, because that can help show they were responding to the event and giving these excited utterances. So you are not, let's put some minds at ease. You're not expected to make a determination in that visit or in your medical record whether the patient's injuries that they present to you with were caused by abuse or perhaps by self-defense or some other mechanism. It is important, though, for us to carefully document any disclosures made by the patient, to document your clinical findings both thoroughly and accurately. And by doing so, you will ultimately be providing the highest quality care to your patient, which is our topmost concern, of course, and will also provide a medical record to the patient that may serve them in the future as a legally recognized evidence of abuses occurred. And if you could go to the next slide, thank you. So what are some proactive tips and things that we see with documentation that you can use in your practice to make sure that you are objectively and completely documenting everything that you can that would ultimately perhaps assist the patient in seeking some legal recourse? First and foremost is if the patient presents by themselves for the visit, it's worth noting that. But if the patient is accompanied by a friend or a family member, it would be important to identify that individual, if possible, in the medical record for that visit where the abuse is disclosed or where you suspect that abuse has occurred, as well as that individual's relationship to the patient, because it lends an additional piece of evidence that we have not just the medical provider who has heard the statements made by the patient about the known or suspected abuse, but we also had another witness to that conversation as well and who they are in relation to the patient. The name and or relationship of the individual who has abused the patient if disclosed. This is always erring in the side of the more information, the better, correct? So if the patient identifies their spouse or their boyfriend or girlfriend or whoever the family member is or loved one, or the aggressor period by name or relationship, then it would be worth noting that the patient says, my boyfriend hit me in the face, rather than I was hit in the face. Be sure, as we always do in medical records, to make a note of the patient's chief complaint and an objective description of the abusive event, being sure to avoid inflammatory language or terms that might show that you are taking a side in what might have occurred. And as we say, be specific. Details are always important. The more information, the better. This statement here, this example, the patient stated, my husband pushed me against the wall last night, is helpful in a variety of ways. One, we have identified the aggressor, her boyfriend. We have stated what happened, that he pushed her against the wall. We have stated when this occurred in relation to the visit. It was the night prior, which will help as far as its admissibility in court. We are also putting the patient's statement in direct quotes, which we'll talk about in a moment, and that is very helpful as far as admissibility of the medical record in a court proceeding. Next slide, please. Setting off the patient's own words in quotation marks is a very good rule of thumb to have, not just in instances of interpersonal violence, but anytime a patient makes a comment to you that you feel it's important to have a direct quote of them. And using phrases such as patient states or patient reports if you're not taking a direct quote, because that shows in the medical record, as well as to any law enforcement or to the court that might be reviewing your documentation at a later time, that the information that you have documented reflects the patient's own words and is not a summary of what the patient shared with you. As I stated earlier, it's helpful to be neutral and objective and don't clean up the patient's language. If we can be as specific as possible to what the patient stated to you in real time regarding the event itself and the impact that the event has had on the patient, then that will lend further credibility to the patient's account and will be more likely to be admissible if the matter ends up being before the court. It's important to describe the nature of the event. As we noted on the prior slide with the instance of my boyfriend hit me and pushed me into the wall last night, we have exactly described the nature of the event, which is more helpful than my boyfriend hit me. So any detail that we can give. The time and location to the extent known or to the extent that the patient is willing to share that with you. If it is pertinent to the history of what the patient is complaining of, if the patient recounts other instances of abuse or neglect by or interpersonal violence, it is important to document those things as well. Always providing a detailed description of the injuries. As I've noted here, the type of injuries that the patient has, whether that is a concussion, whether that is bruising, whether that is a fractured rib, whatever it may be, very specific and detailing every type of injury, as well as number of injuries, such as if the patient presents with multiple bruises over the body on different parts, instead of just saying patient with bruising to body, it's important to note the number of bruises, as well as you see here, the size and location. To the extent that you can help age the injuries, that would be helpful. The patient may relate to you when the injuries occurred, but they may not. But this would be an additional piece of information, whether it is a fresh cut or is a healing bruise. Any characteristics that you can use to describe the state of the injury, that will also help the court in determining when that injury might have occurred. Next slide, please. One of the things I've referenced here is taking photographs. And we talked about the 2001 study where there was only one photograph in 93 instances of an injury. So if possible, we do want to take photographs if the patient permits of the injuries that are known or suspected to have resulted from interpersonal violence. As I noted here, consent should be obtained according to the policy of your hospital or your practice. For those of you who are Norton healthcare providers, I know there are a number of you on the call today. I'm going to refer intermittently to a few of our policies, but in the policy and procedure library on Insight, you will see policy number 7290, which is entitled Clinical Photography, Suspected Abuse, Assault, and Neglect. And you'll see within that we do require consent of adults for photographs. There is an adult consent entitled Consent to Photography, Videotaping, and Authorization to Release Protected Health Information that you should have the patient sign prior to taking photographs. If it is pediatric suspected abuse, no such consent is required. But for those of you who are outside of Norton employment, I would encourage you to work with your respective hospital or practice with your risk management department or legal department to see what your consent requirements are for obtaining that patient consent prior to taking the photographs. We should be sure that photographs should be taken by a trained staff member because of the sensitive nature of the photographs that will be taken. As well as we want to ensure that these are the most detailed, accurate representations, depictions of the injuries that we can have. You'll also note close-up photographs of the face, so that further helps identify that we have putting the patient with the injuries, as well as the trauma areas. And it is most helpful to be using a measuring device of some type, which will help give perspective and help further document the size of the injury. Next slide, please. We don't see body maps quite as much sometimes now with electronic medical records, but to the extent that you do have a body map available to you, I would encourage you to use that to document the location of injuries. We did see in that 2001 study that I believe 8 body maps were used. So that's better than the photographs, but we do want to have as much detailed description of the injuries as possible. So clearly documenting on that body map, again, the location, number, type, and characteristics of the injuries, including the apparent age. To the extent that you are unable to document on a body map or by photograph the injuries, being sure to otherwise document those within the text of your record to make sure that we capture all injuries. And also, as we note here, documenting any lab or radiology studies, ordered medications prescribed, and any referrals given to the patient for perhaps domestic violence resources, or perhaps they're going to need further specialty care as a result of the specific injuries that they have sustained. One of the things that we shared earlier in this presentation was about the excited utterance exception to the hearsay rule. And this is where this is very important for us as, I say us collectively, I'm not a clinician, but us as providers to document the patient's general demeanor when they are speaking to you and documenting that objectively, using terms such as patient is crying or seemed angry, agitated, upset, or even calm. If we can be objective in that, that is going to be more helpful for the patient ultimately in using this medical record to support their claims of abuse if they proceed to the court. It is far more helpful to say patient cried and shook uncontrollably while describing the incident other than patient became hysterical. Hysterical has a dramatic flair to it. It's not as objective. It's a little more subjective. That could lead the court and individuals investigating the claims of abuse to wonder what hysterical in fact means, because it could lend itself to various interpretations. Whereas crying and shook uncontrollably is far more specific. And ultimately, that's also going to be helpful in proving that this was an excited utterance that the patient made to you at the time. It's also helpful to document the family and social history, including current living arrangements. If we have a patient who is within a home that they share with the individual who committed the or engaged in the abusive act, if there are children in the home, if there are grandparents in the home or other individuals, because our patient may not be the only individual that is being impacted by that abuse. Next slide, please. Again, using neutral language, I would always encourage folks to say patient states or patient reports, because using terms, and this is very subtle, but using terms such as patient claims or patient alleges could imply some doubt about the reliability of the statements in the account that they are giving to you. So it's always best to just use objective terms such as stating and reporting. If there is a conflict that you perceive within the patient's statements regarding the injuries themselves or the abusive act, then you can note as such in the medical record and record the reason for the difference if known, but avoid commentary as far as commenting upon the patient's veracity and whether they are telling the truth or not. It's easy for me to say this as the lawyer, but try to use medical terms, of course, and not legalese, such as perpetrator, assailant, assault. You've noticed me kind of lapse into some of those terms just as I've spoken here today, wearing my lawyer hat. But those terms have very specific legal meanings within the court system. So I would, if possible, use, again, boyfriend, spouse, girlfriend, whatever the relationship of that individual is to the patient, best to use those terms instead of using legal terms. Next slide, please. What, and this is a little bit of this is reiterating things I've already stated, but try to not summarize the patient's account. Try to give the quotes of what the patient shared with you. Try not to clean up the language used. Conclusory statements such as this patient is a victim of domestic violence. While that is documenting the claims that they have made to you, it's a legal finding as to whether they are in fact the victim of domestic violence, but also if the patient were to go to court, this kind of statement would lack sufficient factual detail to really assist the court in determining if in fact the patient sustained injuries, which would be the result of interpersonal violence and abuse. Additionally, always important to include documentation of any safety plan, referral, education, or follow-up plans that are made with the patient. Meg has already shared with you the educational resources and the statutory requirement that providers give patients educational materials about abuse and neglect and interpersonal violence. Again, I would share for you, those of you who are Norton employed physicians or who use Norton's EPIC system. We do have those domestic violence resources available on Insight. As Sherry noted in the chat box earlier, I appreciate that, Sherry. You will find that in the policies and forms section, and it'll be under other, where you can find those materials where it can be printed out there in office, if not kept on hand to give to the patient. One of the things we also discussed of, we are only reporting this in Kentucky if the patient is agreeable to reporting it to the authorities and wishes for assistance in doing so. Again, if you are charting within Norton, if you are a Norton provider, we do have within EPIC, there is a domestic violence education smart text that can be used to document education as well as resource referrals. And it can also be used to report or to document when that notification is made of authorities. If you type domestic in the search box and hit enter, that smart text language should become available to you. We also have on Insight, there's a job aid for documentation of APS and CPS referrals, as well as domestic violence charting. If you could go back one slide, please, I'm sorry. Also, one thing that I wanted to share with you is it is always important to establish with the patient a safe way for communicating. Perhaps this is a patient that you have had ongoing care and treatment of for a number of years, and this is the first time that the patient has presented to you with known or suspected injuries as a result of interpersonal violence. Always checking with the patient to make ensure the safe way for you to further engage and communicate with them as needed for treatment of those injuries is important to do. Also, perhaps having your office staff work with the patient, because the patient may have identified the individual who inflicted the injuries upon them as someone that is able to receive information through release of information. Perhaps it's a spouse, where they have identified them as someone who can receive information about the patient's care and treatment. If the situation changes where obviously the patient is concerned or there's fear for the patient that they could be further victimized as a result of the release of that information, we want to make sure that that individual's name is taken off of the ROI, where they cannot receive further updates on the patient's care and treatment that they have had with you. Next slide, please. One of the things that I outlined at the beginning as far as some potential concerns that we commonly identify with providers in documenting interpersonal violence and domestic violence and abuse are privacy concerns, which we certainly have that are unique to these patients. One of the great challenges that providers encounter is how to record that abuse in the patient's electronic medical record in order to do so without increasing further risk of harm to the patient. Because not only is it an issue of the patient's privacy and protecting that, but also one of safety, as we have commonly seen that individuals who perpetrate interpersonal violence upon patients can then retaliate against the patient if they learn or somehow discover that the patient has discussed the abuse with their medical provider. So what I wanted to share with you are some potential things that you can explore with your practice or with your healthcare system that might be ways to protect that information from being released. So if you could go to the next slide, please. One thing that we need to ensure is who has access. So as I mentioned, most of our providers, if the patient enters the practice, they have signed a release of information form, which designates who they want to receive information. The patients can also, in our land and current times of electronic medical record, they may designate a loved one who has proxy access to their electronic medical record, whether that's through MyChart or another system by which they are able to have alerts and data pushed through to them through their electronic medical record. This is the area where we see the greatest concern with those that have proxy access, because there's potential for them to view the patient's medical record, again, through MyChart, which I'll refer to as the one that most of us are very familiar with EPIC, but as well as the partner or family member who is inflicting the abuse could have proxy access, or they could coerce or otherwise pressure the patient to give them access to the medical record so they can see exactly what the patient has reported to their medical providers. Next slide, please. So here are some different protections that I would encourage you to consider with your patient when they make a report of known or you have reason to suspect interpersonal violence. So one, let your patient know how you will be documenting disclosures of interpersonal violence in the record, how you will be describing it, how you will be identifying that sensitive information. And of course, always make sure that you take the patient's concerns about their own privacy or safety seriously. There is also the ability to withhold or block notes from being pushed through to the patient's MyChart or other electronic access using the preventing harm exception. And what I mean by that is I'm sure that most of you on this webinar are familiar with the Cures Act, which was passed by the Department of Health and Human Services. Actually, they issued regulations. It was passed obviously by Congress. But they issued those regulations in 2020, and that really goes to how information is pushed electronically and how information protected and privileged health information is available to patients. And in October 2022, this past year, the Department of HHS expanded the definition of information that is required to be shared with the patient, including all health data elements stored in the electronic medical record. But there are certain exceptions, and they are very specifically outlined in the regulations. But one of the exceptions is information can be excluded or blocked from being pushed through to the patient's chart if the documentation is considered sensitive or could result in patient harm if disclosed. Or is information that is requested specifically by the patient to not be shared. And for instance, again, within Norton Healthcare, which is the one I'm most familiar with, we now have a pop-up block that will appear for our providers prior to the note being signed and entered in the chart. And it will state at the top, reason for blocking. And the provider can state, pick one of three reasons. And the first two, one is sharing this information would endanger the life or physical safety of the patient or another individual, such as spouse abuse, human trafficking, etc. Or the second option is I have discussed this with the patient and patient specifically requested this information not be shared. Those are valid exceptions under the Cures Act and would not be considered information blocking of the patient's PHI. It also would protect that from being pushed through to the patient's MyChart, where the patient or the family member who might be inflicting the abuse could potentially see that information. There are also the abilities within certain electronic medical records to designate notes as confidential note types, which will again put a barrier between that being released to the patient's MyChart. Certain EMR systems or programs have break the glass access that could also be explored for these types of notes. And then also turning off online proxy access to a patient's electronic medical record. That might involve a couple of extra steps of you reaching out to your respective health information management department to speak with them to see about how the patient could go about requesting proxy access to be turned off for their electronic medical record. And so I placed my information there. Obviously, I know we've gone through this very quickly and would be happy to discuss with any of you at any time any additional concerns or specific factual situations that you may face and any documentation questions that you would have in general. Thank you.
Thank you so much, Meg and Sarah. What a great presentation today. As a longtime practicing SANE nurse, I'm especially appreciative of the update. Great information and a job well done. We do have 3 questions in the Q&A section. I think the first one's for you, Mag, who is considered a trained staff member to take photos.
I don't know, I might pass that one to Sarah.
Okay, Sarah, we'll hand that one off to you.
I was muted. Forgive me, I muted myself. So one of the policies I can speak to what we have at Norton. And I would encourage you, if you're outside Norton, to speak again with your risk management department or maybe clinical effectiveness or care management to see what your policies are regarding who is trained. At Norton, we do have a policy. I can't remember if I identified this one by policy number, but it's 7290 that discusses clinical photography for suspected abuse, assault, and neglect. And within that policy, we talk about individuals that we may have on our staff. We especially see this in the hospital setting, who are designated, who have been trained on use of the camera. So you would be able to reach out to nursing leadership within your hospital facility at Norton to see who is designated and has been trained on taking and obtaining those clinical photographs. For our policy, we also state that for areas without social services support, the physician can also obtain the clinical photographs. And that policy also addresses how those photographs should be handled, whether it's sensitive or non-sensitive information, and where those should be saved and stored. So if you're within Norton, I would encourage you to look at that policy. It is very clear cut and outlines exactly who can take that and how those photographs should be uploaded and handled separate from the encounter note in order to ensure privacy of the patient and maintain their dignity. If you are outside Norton, I would encourage you again to reach out to your risk management department or legal department to further get instruction on what your institution's policies require for training of individuals to take photographs.
Thank you, Sarah. Our next question, where can current information be obtained to learn best interventions for the perpetrator and rates of recidivism for those perps who participate in intervention programs?
Well, I'll handle that one. So we do have a batterers intervention program providers certification process here in Kentucky. So if you want to be certified as a BIP provider and accept referrals from our courts to provide these, I think they're now 32-week-long weekly class programs to people who've been identified as domestic violence offenders. KCADV actually runs that certification program now. And so your best bet is to get in contact with me, and I can put you in contact with my coworkers who run our BIP certification program, and they'd be able to provide you with all sorts of information about that way that we hold offenders accountable and try to change behavior. There may be other ways out there, but that's what I'm familiar with. So I'm going to type my email in the chat so people can reach out to me if they want.
Thank you, Meg. And our final question comes from Lisa Coleman. Where can we find the information about how to make a CPS report on Insight?
Absolutely. So there are a couple of areas where I would address you to, Lisa. First, another policy, I know I'm throwing out a lot of numbers, but we have our abuse and neglect policy, which is policy 2498. We also have standard work instructions for abuse and neglect, which outlines specifically step-by-step, including the website down to the detail of how to make those reports to APS or CPS. And those abuse neglect standard work instructions are 7931, as well as the job aid for documentation of APS and CPS notifications that I shared with you all earlier. That actually does not have a number associated with it, but if you just put in abuse or neglect in the search bar, that will come up. But that also gives you some prompts and shows you through Insight and Epic how you could document that APS or CPS notification.
Thank you, Sarah.